Delighted to be here early so we can wrap this up. I'm going to ask Senator Burke if you would be kind enough to open us with an invocation. Number 10.
I have a number. So yes, must be 10. Let us pray. Dear Lord, thanks so much for the great day that you have started and bestowed upon us. Please guide us with wisdom to evaluate the matters before us and act accordingly. In your name, amen.
Thank you. We have two members en route. So Senator Anvatarte and Senator Harrell will join us shortly. But this is a hearing only this morning. So we're going to go ahead and begin in the essence of time, and we have one bill on the agenda today. Again, hearing only. We will take testimony, so anyone who wishes to speak to the bill will be happy to hear from you after the author has a chance to present the bill. So I'd like to recognize Chairman Oliver to present House Bill 923. That is LC 471757S. Is that correct?
Yes, sir.
Very good. Thank you.
Thank you, Mr. Chair. I appreciate very much the opportunity to bring you up to date with the discussion that's been going on for about a year and a half in the House, particularly through the Government Affairs Committee. In my district, in middle of Dekalb, there's been a very active set of development projects and new cities and extensive annexations.
Can I ask you to pull the microphone just for the record? Thank you.
Thank you, sir. Very active development proposals and around annexations and new cities. The city of Brookhaven is a new, very successful city. Emory community, 750 acres, got annexed into the city of Atlanta, and there are multiple city proposals and multiple annexations that are at play and being considered. In DeKalb County, there are probably over 30 development authorities. And across the state, there are probably over 700. And the questions that I have been posing publicly for a good while, there's an editorial I wrote that I included in your package. Who's entitled to know? Do we know how many development authorities? Do we know the amount of debt they've issued? Who's entitled to know? And when are they entitled to know? And what is their opportunity to object once they know a development authority is proceeding with a proposal of tax incentives or tax abatements that will impact the citizens and the impacted governments around it? Within my immediate area around my district, in my district and around my district, there has been litigation, multiple litigations between development authorities, counties, and school boards in relation to who has standing. Who has a right to come to court and to object to a tax abatement, tax incentive package that is going to be owed by primarily a development authority, but at backup is going to be owed by some other government entity, and which is going to impact the budget of the cities and the counties and the school boards? Who's entitled to know? When are they entitled to know? And when they know what the bond validation offering may be, do they have a right to come to court? And in the cases that have come forward in DeKalb Superior Court and Fulton Superior Court, the court has decided on the Superior Court level that yes, the school board specifically is going to be treated as a citizen and allowed to come into court. That did not get appealed because there was a withdrawal or a change in the development plans. And specifically right now in Brookhaven annexation and development authority proposal, there's, I think, ongoing discussions. Most of this activity is North Druid Hills Road, where the CHOA property has annexed into the city of Brookhaven. That's $1 billion project. And Emory has also bought right there on 85 another annexed property into Brookhaven. So these are real decisions and real conflicts. Among the bills that I pre-filed in the fall of 2020, 23, 24, and House Bill 66, we had good hearings in 2021, and House Bill 66 came forward to the committee to the Government Affairs Committee it stated that a school board, for the purposes of a bond validation hearing, shall be granted standing. So that confusion, that ambiguity about whether a school board is a citizen, about whether or not a school board is a resident of a development authority. For instance, the statute says a citizen can object to a development authority if they're a resident of the entity seeking the bond validation. Well, that means I have to be a resident of Brookhaven to object to the Brookhaven bond development, but if I live in Druid Hills, where I live, next door, it's going to lower my taxes. I don't have a right to appear. I don't have standing. This is a confusing area of the law, basically, and the courts are struggling with it. And the question that I ask all the folks that are involved in this is, do you want the only dispute resolution process to be litigation? Or do you want to have the General Assembly give you some rules about what the General Assembly, wants to do about this issue? House Bill 923 came forward through the House at a vote of 173 to nothing, and that is before you right now, and it does two things specifically. I've given you the background on the issue of standing in school boards and who is a citizen and who has a right to appear in bond validations, because I think you need to be, I wish you to be engaged in the broader discussion. In the current 923 that's before you, there's two reforms that I've offered, again, that was unanimously passed by the House. One, there are 4 counties that are entitled to charge per diems as members of a development authority. That's a statute that was passed in 1980, and those counties are Fulton, Dekalb, Cobb, and Gwinnett. The development authorities on the DeKalb County side, I don't think they do allow per diems, but one of the other development authorities in Fulton was allowing per diems for every agenda item. So it was a recognized abuse. The newspaper's written a good bit about this, and they, after the leadership change, they changed that rule. But I thought it was appropriate to put a cap on the per diem that a development authority in these 4 counties, which is probably 50 or more, I can't really tell you exactly how many, should be the per diem that we in the General Assembly receive. The second provision, and this came out of a long discussion about who is authorized to assert any accountability over development authorities. They are created by statute as a tool for economic development, which they serve that purpose, and they're successful in that purpose. That was a historical creation to get around the gratuities charge clause, but who is authorized to monitor any of their behavior? And the initial drafts of bills suggested that any local ethics commission, if you have a local ethics commission in Cayuga County, then they should have jurisdiction. The Georgia Economic Development Association objected to that, and a compromise was reached that the State Ethics Commission would have jurisdiction to hear complaints about alleged ethical violations for all 700 across the state. So the bill that came out of the House was, 1, cap on per diems, and 2, grant jurisdiction to the State Ethics Commission for caps to accept violation allegations. And that was accepted unanimously by the committee in the House. I gave you that little discussion about standing and about who has a right to complain because I wanted you to hear. I know that people coming forward, the ACCG supports a broader bill than passed the House. My county commission, Jeff Rader, who represents our area of this high development and high conflict area, is with us today. And I think that he has probably the most in-depth analysis and has worked with the ACCG on this issue. The Georgia Municipal Association also has been in support of this bill. I think there's a reason for us to look at these issues that are confusing a little bit to the courts and make a decision, at least have a discussion, who's entitled to know, what are they entitled to know, when are they entitled to know, and if there is an impact on their jurisdiction, a city or a county, an impacted school district, do they have a right to make their case in court at the bond validation hearing. Mr. Chairman, I'm happy to answer questions or allow you proceed if you want to hear witnesses, however you wish to proceed.
Let's begin with questions from the committee. Number 6, the majority leader.
Thank you.
Leader.
Thank you for bringing this in. I do a couple of questions, though, and it's not a stump the chump. This is a legitimate question on my part. You did the Brookhaven, Druid Hills example a little while ago.
Yeah.
How far out can you go? I mean, is it communities next door to each other, next counties over?
If we're talking about the bond validation hearing, and there is another procedure that you are going to hear about in 1461, which comes out of this annexation study committee that I was on, about how you can dispute annexations that are sometimes contingent on bond validations. That's in front of DCA. But in terms of the bond validation hearings, the statute says you have to be a citizen of the entity seeking the bonds. So that would limit objection by a citizen to citizens of Brookhaven only. And I, in Druid Hills, would not have any right to know or object to it. Now, in the current bill that's before you is not considered, but in terms of what we're going to talk about this morning about who has standing, I think it should be anybody who lives in an impacted government. I think the drafts of earlier bills have been who is impacted by the tax incentive, tax abatement. The school board is impacted by these Brookhaven examples by many $1 million. And they should be, in my view, have standing to make a case. And the case that they need to make, and this is set forth in the annexation procedure, but not necessarily the bond validation hearing, does it make a financial difference to them in any significant way?
So that's why I was asking, because I misunderstood you then. I thought the school board did have standing. I thought that's what you were saying before.
A citizen, only a citizen has standing. And what the court has been confused about, understandably confused based on the ambiguity, is a school board a citizen. And if a school board's a citizen, that means you got to say the citizen resides in Brookhaven. Well, does the school board reside in Brookhaven? So there's a reason, in my view, to take that issue away from the litigants. I don't think litigation should be the dispute resolution process in bond validation. Who has the right to come to court? But that's for you to consider.
Okay.
And that was controversial at different times in different ways, but ACCG and GMA feel like they need it, and I, as a citizen next door to Brookhaven, I have 3 school districts in my district, 2 independent and 1 county, and they're all impacted by these tax abatements. Tax abatements is not defined anywhere in our code. This is all a creation of smart people who've created opportunities for economic development deals, and the question is, who manages it, who monitors it, and what should be the dispute resolution process when the cities, the schools, and the counties are in dispute about it.
Thank you. The chair recognizes Senator Robertson.
And again, on the majority leader's point, it's definitely not attempting to stump anybody, but you said there were 700 development authorities here in Georgia. Mm-hmm. Do you know how many of the 700 do per diems?
Only 4 counties are allowed to do per diems, and I estimate in the 4 counties there are probably over 50 development authorities. You know, my little city of Decatur Square, they have a development authority, and they have a downtown development authority, and we created a special use development authority to buy the Children's Methodist Children's Home. Mm-hmm. So just in our little fort, and we have 13 cities in Dekalb, so you see that they mount up. There is a list of development authorities over at DCA, and I've asked Christopher Nunn, where is that list? 159 counties, 500 cities. Some people say they're 900. How many of them are active? I can't. There are a lot of them.
Thank you.
But there are only 4 that are allowed by statute to grant per diems. Those are only the 4 counties of DeKalb, Fulton, Cobb, and Gwinnett.
Okay, and I'm sure after this legislation becomes public, there'll be several others maybe lining up to attempt to get under that umbrella. But I do appreciate that.
Chair recognizes the minority leader. Oh, sorry. Is that right? Sorry. Chair recognizes Senator Burke?
Thank you, Mr. Chairman. Did the Campaign Finance Commission respond or weigh in on the House side on whether they were willing to take on this
I'm trying to remember
oversight?
exactly what conversations we have. This idea, this compromise came through the chamber, Metro Chamber, and I personally haven't called them. I intend to do that.
Okay, I'm just curious, since we're giving them extra duties, what
We
their
are.
thoughts were.
True. The chair recognizes Senator Matarte.
Thank you, Mr. Chairman. So I'm going to ask the opposite of Senator Robertson's question. Is there any reason why we would just maybe eliminate the per diem altogether to have uniformity across the entire state?
Would have no objection to that. I have not, that idea has not come forward. I don't think many, I can't, there may be somebody who can tell you how many charge per diems or collect per diems. I don't think it's many.
Okay. I was just curious. Thank you.
Other questions for the author? Mr. Leader.
I was hoping somebody else was going to weigh in on this. I'm going back to the area. My concern is that communities could weaponize this against each other for competing for same type projects, and then I'm afraid we would convolute the issue even more if you got one area within the metro area that's looking at the same type, and there can only be so many and so much investment that they would say this would have an impact on me. So I'm just not comfortable with it. It's kind of a nebulous who is impacted by. And I understand what you're talking about, the school boards, but if a school has a property within that district, they would be a citizen of that district, I would assume. If you're gonna have an entity as an individual, then it's the whole girth of the entity, not a single point of it.
That's a very fair question, and that's what the court has been struggling with, and arguments on both sides. The school district is or is not a citizen. Does the school district reside in a development authority area?
Does it have an address? If it has an address.
In Brookhaven, I know there are elementary schools, but the address for the unincorporated, for the Dekalb school system, and that's not one of Independence right there in Brookhaven, the address is over on Stone Mountain Industrial Boulevard, if you look at what their legal address is. But they certainly have property in Brookhaven. There are two precincts I have in Brookhaven. They're both schools in the city of Brookhaven.
All right.
I've also included some other, there's a great deal of attention to these issues right now. If you read the newspaper, there is a lot of fair attention, I think, to what are the deals, who knows about it, who's entitled to know about it, and who's entitled to complain.
For clarification, Madam Chair, if a citizen has standing and they can then express their position on the abatement, that is before a judge or
Superior
Court judge, and the judge then rules as far as whether or not the abatement would be allowed. Is that true?
Yes, that's correct.
And so what you're asking for is for an entity that's impacted by a potential tax incentive or an abatement to have standing. Is that
Yes,
not? Is that in this bill, or is that
That is not in this bill.
It's a separate
been
bill.
in previous bills under these numbers. This
Right.
bill has changed. But since we had, and I appreciate the opportunity to have a real discussion this morning, I wanted you to know what the discussion's been about. The discussion has primarily been about standing. Who has a right to complain? What is their standard for complaints? And in 461, you're going to see that the compromise reached in that. I was on that annexation study committee in the dispute process through DCA, that they decided ultimately the bill that y'all will consider, I don't know where the bill is right now, that school systems have a right to be notified of the annexation, which usually is frequently contingent on tax incentives and abatements, but they don't have a right to be in the annexation dispute process. Now, I'm not going to argue that right now. That's not what came out of the study committee, but that was kind of a compromise that came forward. We have, I would say, half of Georgia, everything inside the outer perimeter, your area I would consider, is high development potentials. lots of competition. And you will hear from the county commissions, you might hear, that it is the competition and the shopping of deals that some people believe is highly problematical. The City of Atlanta grants a development authority a project with tax incentives on the condition that they give low-income housing provisions. The developer goes immediately next door to City X and gets a better deal. He doesn't have to do housing development, low-income housing development. That's the competition we're dealing with right now. Whether you call it weaponized or you call it capitalism, is it good for the taxpayer? What's good for the taxpayer? And that's a fair question that I think is part of all this.
Other questions for the author? Let's move to testimony and get some input from those who are here. I'm going to first recognize Kevin Shea. Kevin, if you'll come forward.
Yes, sir, Mr. Chair.
Georgia Economic Developers Association, GEDA.
Good morning, Madam Chair. Good morning, Mr. Chair and distinguished members of the committee. Thank you for the opportunity to be with you this morning. I don't know that this is on, but I'm Kevin Shea. I'm president of the Georgia Economic Developers Association, or GEDA. GEDA has nearly 700 members, many of whom are executive directors of development authorities or chambers of commerce, those that are charged with improving the prosperity of their communities through the creation of new jobs and investments. GEDA members are employed in over 75% of Georgia's counties. GEDA has a neutral stance on this bill. We are supportive of the per diem provisions, and I will say that to my knowledge, to our knowledge, there are only two development authorities that are our members that get per diems. One is the Development Authority of Fulton County, and the other is in Henry County. Now, in Henry County, I think it's across the board that it's all governmental entities can get per diem, and it's a set deal. But I'm not familiar with any other development authority that has that provision for per diem. And when this came out in the newspaper, many of our development authority directors around the state were saying, yeah, we want to get a part of that. So how do we do that? So we're offering it to 4 counties now, evidently. But we're supportive of the per diem provisions. It really doesn't bother us at all to have that. In fact, well, let me go on. And we're not opposed to the State Ethics Commission clause. We appreciate the difficulty that Chair Mary Margaret Oliver has faced in her county, but we feel that it's a local issue that should be dealt with locally and not by changing the state law. We have, as I mentioned, roughly 75% of Georgia's counties that are represented by GEDA members, and I can't say that every county does it perfectly, but most every county does it very well, of communicating with their local organizations, their school boards, their cities, and their counties. And it's something that we encourage that on a regular basis. We are set with a particular provision of granting incentives, and many of those are through development authorities. And so those kinds of things need to be talked about among the local community with the city, the county, school boards, any other entities that are involved. And so we encourage that, and we continue to preach to our members that they need to be doing that on a regular basis. We are, and I'll say a couple of other things, that the standing issue is something that it's the current law. We feel that it is appropriate as it is, where an individual as a resident can, as a citizen, can object to a particular deal. If they wish, if someone's on the school board and wishes to object, they can go and have one of their members who's a resident, a citizen, be able to object to the deal. I would say also that those who are entitled to know are the public at some point. And I think that one of the issues that we're not talking about is confidentiality. When you're dealing with projects, you have confidentiality that is absolutely critical. If you share information publicly before a deal is announced or decided, you many times can kiss that project goodbye, many times to a competing state, not just in other places in Georgia. And I would say that entities that appoint individuals to these authorities. And in our cases, it's mostly counties and sometimes cities, and sometimes there are other entities as well. But that they are the ones who are responsible for making sure that these people do their jobs right. They need to be watching their organization and making sure that they're doing the right thing. So it's a matter of working with the appointing entities and making sure that they're updated as to what's going on. And I'll say also that development bonds, in most cases, are not having the financial wherewithal of the development authority at risk at all. It's a pass-through deal in most cases where the organization that's getting a bond is paying off that bond based on its own credit and standing. So as it relates to this particular bill, we are pleased that several items were removed from the bill in the House, including the removal of directors, organizational standing, which we've talked about a little bit this morning at the bond validation hearings, and disclosure of incentives, which we haven't really talked about. All of these items would have had a very detrimental impact on economic development in the state of Georgia, and particularly the rest of the state. So GEDA is neutral on the bill as it is. However, we would oppose the bill should there be any attempt to add additional clauses, especially those that we've talked about that were deleted in the House version. So that's my statement, Mr. Chair, and be glad to answer any questions.
Chair recognizes the Minority Leader for a question.
Thank you, Mr. Chairman. I want to ask Representative Oliver a question about whether it should be local legislation or statewide as we have here.
The creation of development authorities is usually local legislation. Of course, we do have multiple county development authorities now that are created but different way. The statute, though, about the bond validation is a statewide statute. So it would not be a local matter about whether the city of Stonecrest or the city of Decatur would have a right to have standing a bond validation hearing.
Okay, and can I continue? Mr. Shea, you said you're neutral, but you have several opinions about this piece of legislation. Is that neutral?
We're neutral as the bill is right now, but the items that were removed, we were against, and so it's not in the bill now. But so if they were attempted to be added back, then we would be against the bill. But as it is now, we're neutral. We're not in favor of the per diem. We're okay with that. And the Ethics Commission clause, the fact that the local element was removed was okay with us. We were concerned at the local level that there would be targeting or issues where people would be falsely accused, and it would be very difficult for those individuals that are on the development authorities themselves, but even for future members to want to go on to development authorities if you have issues like that. So we didn't want the politics to be involved. And that was the reason the development authorities were created. One of the main reasons that development authorities were created in the first place is to be outside of politics, if you might say, an arm's length from politics. But you have politicians appointing them to these positions. So we were concerned that that would be something that would be increased and would not be a good situation.
Politics always have a way of creeping in, doesn't it?
Oh, yes. Oh, yes.
Let's continue with our next witness to continue to gain some insights. The chair recognizes Jeff Rader with the Dekalb County Board of Commissioners. Mr. Rader.
Thank you very much, Mr. Chairman, and thanks to the members of the committee for rising early and being here today. I am Jeff Rader. I'm a member of the Dekalb County Board of Commissioners, and I have been pleased to study this issue extensively. As Chairman Oliver had mentioned, by virtue of the multiplicity of jurisdictions that exist in DeKalb County, we and the pressure and the amount of money that is going into real estate development in the urban core of this state, there's been increasing incidence of the use of these deals in order to give economic advantage to certain beneficiaries. I want to give you a little bit of context on Development Authority, since I know that Chairman Burns has been a member of the Development Authority, and there may be other members of the committee that are aware of the mechanics, but many of you aren't. And in many ways, it's, development authorities are kind of a dark art when it comes to trying to, generate economic development. And they have a valid purpose in doing that. And I certainly support the use of tax abatement in many situations. But tax abatement, as Chairman Oliver had mentioned, is essentially an unregulated power of development authorities that is derived from their status as a subdivision of the state. Now, county governments and city governments are also subdivisions of the state. Their assets are not subject to property tax assessment and payment, and school systems are subdivisions of the state. And you can understand why you wouldn't want to tax those facilities that are used in serving the public directly in those ways. But a development authority is likewise classified as a subdivision of the state, and therefore any assets that are titled in their name are not subject to property taxation by any entity whatsoever. Now, there are valid reasons that the development authority should have that power. For instance, in many areas, development authorities operate industrial parks. They buy raw land, make improvements, and then sell sites to businesses who employ people there, and that is a clear and valid public purpose. In other cases, their development authorities are working strategically to bring businesses that would not otherwise locate in the state or a jurisdiction to bring them here, and they're in competition with other states, typically for an industrial plant or a headquarters operation, and those incentives are often key in being able to bring those businesses to the state of Georgia and to confer the benefits of that employment and economic activity. But then the third category is when a development authority takes a productive private business, changes the name of the title into the development authority's title, and then magically that business is not subject to property taxation. And it may be an industry, but increasingly it is apartment complexes or retail complexes where these are businesses that generate, substantial public service delivery demand and are competing with other like businesses within the same market. And so they then, if they receive this abatement, have a financial advantage over other competing businesses. Now, it's important to recognize that these are not businesses that are going to locate in South Carolina or, in California. They are dependent upon the local market. An apartment complex or a retailer will not locate in another jurisdiction because they are trying to serve that local market. As you know, these are very localized types of needs. So in a situation like that, it is local market demand that ultimately drives that decision, and tax abatements are simply icing on the cake that are either have the effect of inflating the return on the investment, but perhaps more perniciously can have the impact of inflating land values, because once a developer builds a tax abatement into their pro forma for their development, then all of a sudden they can pay more for land than somebody else. The problem is that then after that, once the land values start to rise in an area, then everybody needs a tax abatement, and you have a vicious circle associated with that. So I think that that's an important consideration when you're looking at these local serving businesses. Now, as Chairman Oliver mentioned, the words tax and abatement do not occur together in the official code of Georgia. It is derived from that status that I had mentioned, and smart bond lawyers figured out how to go through that process. It's called a phantom bond process, interestingly, where a developer will go to the development authority. The development authority will issue bonds, quote unquote, to buy that property from the developer. But then the only person that buys that bond, and no money actually changes hands, is the developer. So the title goes to the development authority. There is a clause always in the contract that allows the property to revert back to the private owner at the end of the tax abatement. So they're not harmed by it, but it is a means simply to shift the title. And this power is exercised by unelected boards. They're appointed And those boards derive fees from the transactions to award the tax abatement. So in some cases, in many cases, Fulton County's Development Authority is entirely funded by the fees that are derived from the transactions that they make. So they have an incentive to do these deals in order to put money into their bank account. And these boards can, there was some question as to whether or not there should be, self-regulation. Well, a development authority appointed by a municipality can abate the taxes not only of the municipality, but also of the general government of the county, which often comprises a larger share of the tax bill than does the municipality, and the Board of Education, who is not party to the process in any way. So a municipality can abate the taxes of counties and school boards. A county development authority can abate the taxes of the municipality and the school board. And those appointing entities are not necessarily accountable to the other jurisdictions whose taxes are being abated. So I think that that's an important alignment issue that really needs to be resolved in order to make this assured that everybody is being treated as we want all of our stakeholders to be paid, the attention that they need to be paid. Tax-exempt ownership of economic development assets is appropriate, and I think that it works very well where you have alignment between the leadership of the different localities that are involved in the process. In Metro Atlanta, there are so many different entities and they have so many different interests that unity of local control ultimately starts to fall apart. And we've researched this. Most development authorities in the state, as well as this bond validation process, are regulated under general statewide legislation. So it does not appear possible to adopt local legislation that would regulate development authorities within a jurisdiction where we have the problem. The only means of trying to narrow this at this point that we've identified is by connecting this to this more narrowly conferred per diem power, which essentially affects these four jurisdictions. So that is an option if you wanted to try a regulatory framework out and to focus it more narrowly where the problems seem to be occurring. Using that per diem factor would be a means to accomplish that.
If you could wrap up your testimony,
Yes,
so we can
sir.
go to questions.
Okay, sure. The last thing that I would say is that this issue of the bond validation process is a general process. Bond validation is required for water and sewer bonds, for school bonds, all sorts of different bonds. These, because it's a subdivision of the state, also has to go through that validation process. The purpose of that process is to ensure that the issuance of the bonds is for a valid public purpose, and that's what the judge is basically ruling on. The standing issue is an important one because in most cases an individual will not have the resources or the sophistication to be able to mount an appropriate even petition for standing. And I have seen in validation hearings where qualified citizens are denied because they didn't follow the right procedure from the court's perspective, and so they ultimately were denied on a procedural basis. The other taxing entities have the resources and the sophistication to be able to bring these issues to the table. And finally, I will say that I believe that by conferring validation on these capable entities, that what will immediately happen is that intergovernmental agreements will be negotiated between those entities that will structure how tax abatements are used in that particular area, so that there is a negotiated agreement as to where they should be used, and that will keep this issue out of the courts and instead put it into an intergovernmental negotiation mode, which is more appropriate for its use. So thank you.
Thank you. Thank you, Mr. Rader. The chair recognizes the majority leader.
Thank you, Mr. Chair. I'm a little slow. I feel like there may be an amendment coming, though, because we're spending a whole...
It's a possibility, but not today.
It's just we've spent
We have
40 minutes
40
talking
minutes,
about
right.
stuff that's not in the bill yet.
That's right.
And also, I think you undersell. I got a lot of friends that live in DeKalb.
Yes, sir.
I think you value their ability to protest because every time I go through there are signs out all over the place. So y'all can organize pretty well over there. I did want to go back to you're talking about your phantom bond though. Mm-hmm. There's another side that you didn't mention is the. I love the minority leader down there.
Great comment.
Another side that you didn't mention that those bonds also hold the developers' feet to the fire. That they're actually going to achieve what they promised they were going to produce, if I'm not mistaken.
Well, that depends upon the terms of the particular contract. We've had a situation where a developer promised affordable housing in their in their commitment, but as it turns out, it was not enforceable within that contract. The phantom bond aspect of it is simply a means of being able to put the property into the title of the development authority without any money changing hands. But each of those deals is different, and so it depends upon the details of that negotiation in order to ensure that the public interest is protected.
Okay, thank you.
Chair recognizes Senator Invotate.
Thank you, Mr. Chairman. Commissioner Rader, long time no see.
Yes, sir. How are you?
I am great. Having flashbacks to the past. Haven't been to Mayor Pro Tem Adorable. These are fun times. So I'm going to ask a couple questions, and I think some folks in the room and maybe a couple of my colleagues will probably know where I'm going with this. But in your opinion, what is with economic development? What is the role? What should be, in your opinion, the role of a school district?
Well, I think that school districts certainly have a stake in economic development. Obviously, the graduates of their systems need jobs, and that's what economic development will bring them. They need to have a growing tax digest so that their resources can be increased. And so I think that they do have a valid and legitimate role in economic development. However, it needs to be a understanding that is cultivated and is negotiated, because otherwise, if their resources are undermined, then they become defensive in that particular way, and they act reactionarily in that particular case. In Doraville, I think that the school board was not disposed to deal with an important economic development project. And what I would suggest is that by developing IGAs around these issues, that we can educate them and to bring them into the economic development community.
So one of the things I find fascinating, maybe it's really not fascinating, but it's kind of the times we're in, is that we're seeing in a lot of communities with the fast pace of growth, whether it's housing growth, business growth, whatever you want to define growth, population growth. I think kind of like what I experienced when I lived in DeKalb many years ago. There's this kind of knee-jerk reaction because I think we're all, we're lying to ourselves if we keep saying the state's not going to grow. And I think there's appropriate ways to handle growth. But focusing on, the education system and basically the powers under the Georgia Constitution, and I think, the clear paths of when we as a General Assembly are allocating money to a school district that goes into the classroom, but we start seeing dollars diverted to either pay for attorneys or potentially set up school districts to have development powers, maybe in deciding development. Does that give you pause? I mean, I know you're a county commissioner, but what is your view, or in terms of, we're potentially taking funds out of a classroom, impacting a student and teacher to basically stop growth? Like, should that power reside with the county? Should that power reside with the school district? Or is this a broader conversation the General Assembly needs to have across the board?
Well, I think that, as I've mentioned, particularly when it comes to apartment and retail development, I do not believe that those decisions are made based upon the tax abatement, because it is fundamentally a local market-based decision. And those projects generate service demand, and certainly for apartments, they generate school service demand. So I think that uncompensated new demand is a legitimate concern of the school board. However, I do think that part of the problem is that we're not thinking, strategically about this amongst these entities who have the capacity to do so. And, the amount of money that's associated with, getting up to speed on this is money that is well spent, I think, in bringing the school board more into a knowledgeable situation. It seems as though the more sophisticated or complex an area of responsibility is, the more narrowly focused that a agency will be when it comes to their skill set. And what I would suggest is that by bringing them into this and forcing them to work collaboratively with the other players in the economic development field, they will develop a broader understanding and will be better contributors to the economic development.
So, I know.
If I could.
Yes,
We
go
have
ahead, Mr. Chairman.
one more question. If it's brief, we have one more witness we need to get through. We spent 45 minutes on good discussion, but I have to let ACCG make their presentation.
I can ask my question offline.
Thank you. Thanks, Senator.
Thank you.
The chair recognizes Kathleen Bowen with ACCG.
Mr. Chairman, I didn't talk about the issue of how a Development Authority member gets removed.
But that's not a part of this bill. Is that
Not
true?
yet. No, sir, it was.
I'm sorry. We're going to narrow the focus to the contents of this legislation.
Okay, Kathleen Bowen with ACCG. First off, I really want to thank Representative Oliver for continuing to have these robust conversations around development authorities. I just wanted to state, first of all, we do see this as a statewide issue. I know the focus today has been on Dekalb and Metro Atlanta, but we do have examples around the state. And one, yes, you're right, Senator Dugan, ACCG would like to see an amendment that would allow bond standing at the bond validation hearings for those affected entities. And the main reason is because we have examples where a city development authority gave 100% tax abatement to a housing apartment complex. The county has service delivery issues to that, and the school system certainly has service deliveries to that, and we're not going to receive taxes on it for 20 years. So we do see a problem, particularly around housing projects. Not the other ones so much so, but when there's a housing component, there's still service delivery issues that the county and the school system have to meet. And the bond validation goes the other side. If the county development authority were to do something that the city had issues with, they would have standing. So it cuts both ways. I know we're talking about city versus county, but it does, if this amendment were to move forward, it does cut both ways. I will end there. I just wanted to make sure y'all know it is a statewide issue, and we do have examples from other parts of the state.
Thank you. Thank you. I would like to just focus back on the bill itself. My understanding of the bill would limit per diem for development authorities in counties that are 550,000 or more in 1980 census. Is that correct?
Yes, sir.
To the state level. And the second thing that this bill does is it makes any ethics challenges the prerogative and the responsibility of the Georgia Government Transparency and Campaign Finance Commission. Is that correct?
Yes, sir.
Thank you. All right. Any further questions from the committee for the author? Again, thank you. I appreciate your time this morning. We've had a robust discussion. The chair would like to acknowledge the fact that Cindy, forgive me, is not here. Cindy Battle. Cindy Battle is not here, and I want to acknowledge the fact this is the first meeting in 2 years that Ms. Battles has not been in attendance. So y'all have a great day. Thank you.